Thank you, Mr. Chairman. I'm pleased to introduce H.R. 2675, the Protecting Our Courts from Foreign Manipulation Act. This bipartisan legislation addresses a serious threat to the integrity of our judicial system by foreign actors who engage in lawfare against U.S. individuals and businesses for nefarious purposes. Due to the lack of reliable disclosure requirements today, foreign states with adversarial interests can secretly fund lawfare against U.S. individuals and businesses to harass or intimidate. Because neither the courts nor many of the parties may be aware of their involvement, these cases also represent opportunities for foreign interests to misappropriate proprietary information and technology. For example, a foreign adversarial government may seek to benefit its national champion by providing funding to a patent assertion entity to engage in a litigation campaign against a key U.S. competitor. If that U.S. company is unaware of the involvement of the foreign government, it will not know that the lawsuit's intended to benefit its foreign competitor. It will not know that the plaintiff's lawyers are secretly being paid by that foreign government, and it will not know that it has to seek extra protections from the court to ensure that its confidential technical information does not fall into the hands of its competitor during discovery. If the court is similarly unaware of the foreign government's involvement, it will not know to scrutinize the plaintiff's discovery requests or to issue extra protections in its protective order. The secret involvement of foreign states in our legal system puts our citizens and companies at risk, clogs our courts with improper lawsuits, and exacerbates the disparity between the fair treatment in U.S. courts and the unfair treatment of our companies and citizens in litigation abroad. This legislation would curb these practices. It would require at the outset of litigation the disclosure of any foreign person, state, or sovereign wealth fund other than an actual party to the suit that is providing monetary support. This disclosure requirement applies to all such arrangements, including those that are contingent upon prevailing in court and regardless of whether the recovery is a damages or fee award through a judgment or settlement. The bill contains related provisions requiring party certification and production of documents pertaining to the disclosure, and it makes the failure to disclose subject to litigation sanctions. Most importantly, H.R. 2675 prohibits third-party litigation funding arrangements in which a foreign state or sovereign wealth fund is a source of the funding. Finally, H.R. 2675 requires the Department of Justice to report to Congress on the identities and sources of funding in federal cases where foreign-funded cases are litigated, the total estimate of foreign money in federal litigation, and the types of cases that are funded by foreign sources. These robust provisions will help put an end to foreign abuse and lawfare. Please join me in supporting this bill to protect American citizens and our private sector. I yield back.
Gentleman yields back. The chair now recognizes the ranking member, Mr. Raskin, for an opening statement.
Chairman, thank you very much. You know, when I first saw this one, I could hardly believe my eyes because I had just been reading an article about Donald Trump's $400 million airplane that he received as a gift from the Qatari government. And of course, this committee knows about the tens of millions of dollars that he's received in unconstitutional foreign emoluments, which would violate Article in Section 9 from Saudi Arabia, United Arab Emirates, Indonesia, Egypt. We've released reports on all of this stuff. So this bill is now targeting, if I understand it right, financing, third-party financing of litigation that either directly or indirectly, whatever that means, comes from any foreign source at all. And these are entities that actually have a right themselves to go to court in America. So it's hard exactly to see why there should be a ban on their being involved in other litigation. Don't we just leave that up to the market? I mean, certainly that's Donald Trump's solution, and he's violating the Constitution directly. I think I picked up the newspaper yesterday. His family is now going into business with the Saudis again for billions of dollars in terms of some development in Saudi Arabia. And anyway, look, today's two bills instituting so-called transparency measures into third-party litigation funding are obviously nothing more than giveaways to big corporations that don't want to be held accountable when their actions violate the law and harm people. Third-party litigation funding is perfectly lawful, it's perfectly normal, and it's perfectly consistent with the rules of professional conduct and ethics. And if anybody uses it in a way that violates the law or those rules of ethics, they can just take it to court. Today, there's really no problem. Third parties invest in litigation, by the way, for liberal groups, centrist groups, and right-wing groups. I'm going to distribute a letter to all my friends from the Tea Party Patriots when we get to the next bill, where we've got some of the most distinguished conservative and MAGA lawyers in the country opposing the Litigation Transparency Act. Ken Blackwell, the former treasurer of Ohio is going to be opposing that one. Tim Jones, the former Speaker of the Missouri House. Stephanie Smith from Alabama, I think in Representative Moore's district. On and on. These people understand how dangerous this is, right? Third parties invest in litigation in return for a share of the contingency fee or the damages awarded should the party they've invested in win the case. This is a practical, market-based solution to the problem that the majority of Americans face when they think about going to court to obtain justice against a deep-pocket defendant. Litigation is extremely expensive, and deep-pocketed corporate defendants will try to spend you into oblivion rather than give you the opportunity to win in court. Third-party litigation funding helps ensure that nobody, the little guy, the middle guy, the big guy, left, right, center, is denied their day in court simply because of financial obstacles and barriers. And it works. People who couldn't afford to get their court heard have been able to overcome major financial obstacles with the help of third-party investment. But because third-party litigation funding helps ordinary citizens take on the big guys, it's become a target for big business groups that would much prefer that people not have the ability to bring lawsuits against them. These businesses and other corporate interests want you to believe that these agreements are somehow dangerous or nefarious. They suggest that actually third-party funding is somehow giving ordinary people an unfair advantage against large, powerful corporations that can purchase all of the legal help that they want. So now these parties have proposed a bill that they would say brings transparency to the system. In reality, today's bills would impose a form of abusive transparency and use it as a tool to dissuade funders from participating in third-party litigation funding agreements. Forcing litigants to disclose private investors would undoubtedly have a chilling effect on TPLF usage. If this is somehow a foreign policy matter, a matter of national security, how come we're not hearing from the State Department? How come we're not hearing from people interested in foreign policy? I'm delighted that my colleagues have an interest in what foreign governments are trying to do to influence us here in America, but I can guarantee you it's got nothing to do with foreign sources indirectly affecting parties whose causes of action must be adjudicated by American judges and juries. It has to do with direct payoffs to the President of the United States, like the $400 million Qatari airplane and the millions and millions of dollars that were spent on rooms never used at the Trump Hotel by the Chinese government and by the Saudis and United Arab Emirates and so on. So all I can say is if we want to have a hearing about illegitimate foreign influence in America, let's do it. But this is an extremely attenuated Rube Goldberg contraption to try to get at it. I'm going to oppose both of these bills today. I'm really going to encourage my colleagues to check out the letters pouring in, not just from liberal public interest groups, but from conservative public interest groups saying, do not go down this road. I yield back to you, Mr. Chairman.
Gentleman yields back. Without objection, all of their opening statements will be included in the record. Chair now recognizes the gentleman from Virginia to offer an amendment in nature